Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. No matter where you're up to in your divorce journey, disclosure will be part of the journey. This episode, we're going to cover a lot of questions asked by you, the listeners, but also what it is, when you'll need it, what it's used for, and how you can present it. But also what happens if your ex doesn't do it, or what happens if you don't want to do it. We're going to talk about all those different types of disclosures, and also we're going to give you a handy, free, downloadable disclosure checklist. So stick with us to the end and we'll tell you how to do that. Welcome, Mum.
Hello, Laura. Hello, everyone.
So disclosure has become a huge part of everybody's journey recently, Mum, more than the old days. Why is that?
Well, disclosure has always been very important, but not everyone abided by it properly. So disclosure for people who haven't got to that delightful part of their journey yet is when you give documents to each other that prove what you've got in the bank or prove the things that you're saying. Okay, it's also superannuation.
So
and so
children
forth.
or property.
Children or property, there's an ongoing obligation of disclosure from the very beginning. And that's a good thing. You shouldn't have to be issuing subpoenas or wondering if they're hiding something. So the court puts that obligation fair on each of you, and you actually have to give an undertaking to the court that you have provided full disclosure. And also, it goes on all through the case. So if you get a document today, it needs to go to the other side if it's relevant to the case.
Right. And I know you're talking about court, but if anybody's listening who's nowhere near court, you also need disclosure right at the beginning with the pre-action procedures before you even go to mediation. Is that right?
Yes. And this is a real big change. This was when the Central Practice Direction came out in September 21 and the courts merged. They identified that often in the old system, people would get pretty well all the way to court before everything sort of came together and they could see for the first time what everyone had and what the property pool was going to be and what had to be divided. So the court has issued this direction and made rules and penalties for not complying that you do all of that work at the beginning of your case. So it does make a case more expensive at the start for people if you're represented by a lawyer, but it should shorten the time that people are in the court. And ultimately, I think the court's trying to get people through the system within 12 months instead of, let's face it, the years in Australia in courts.
Yes.
It was years.
So we're going to give you some tips on how to keep your costs down when it comes to disclosure, because there are some things that you can do. And so if anyone's listening, whether you're in a court proceedings or whether you're about to go to mediation or if you're just about to leave your partner, this is a great episode for you because, again, like Mum said, the subpoenaing is a thing that had to happen because people weren't disclosing.
That's right.
And we do a DIY discovery episode that you can click on in the show notes and listen to, where we talk about how to do your own discovery to find out what their disclosure should be. But this episode is about disclosure. Yes.
Which is where I think a lot of expense happens at the beginning. When you find a document, you give it, your lawyer asks you for a document, you give the document to your lawyer, they read it, they charge, they do a list, they send it.
Yeah. So no matter where you are, let's have a listen to it. So first of all, Mum, basically it's any document.
Yeah, it is. Any document relevant to the proceedings.
Right.
I remember as an article, can I do a story?
Yes.
I was a young article clerk in a firm and someone came in, they said, "You want my documents? Here they are." And he had a drawer full of stuff. He tipped it into a black garbage bag. And because I was the lowest of the low in that law firm, I got the job of going through it. And it had lotto tickets and matches and, and it cost Our Lady a fortune, even paying just my baby rates. So this stops that sort of nonsense because you can get smashed by disclosure from the other side and it's just irrelevant. And, so it keeps everyone's costs down.
All right. Now, there's a basic list of disclosure that is required in the Central Practice Directions.
Yes.
And that's in our checklist. But there's another list for disclosure as well in one other manual.
Oh, I think it's in Rule 601.
Yes.
I think that's the
Yeah.
one. And that talks about disclosure, whether it's children matters. This is family court in Australia. But, so and so with kids, it might be financial. It might be how much you've paid for their, I don't know, their gym memberships or their eyeglasses or whatever it is.
Or medical records
and
reports.
stuff. Yep, you might have had a child diagnosed with something. You put those records in. All of the things that are relevant to the children. And it might be if they've, even to some extent, what your plans are for the future. If you've got a solid lease on a house, you disclose that in a
so
way.
it's not even a document. It's disclosing your plans.
Well, no, the documents, mostly it's the documents.
Okay.
Yeah.
All right. Okay.
So, and
well, let's have a look at the ones that are in the central practice direction.
Yeah.
So the generic ones is your 3 most recent tax returns. So that's basically the last 3 years.
Yep,
Yeah.
and assessments. But don't get hung up on it. If you haven't done this year's tax or last year's tax,
That's not the end of the
world. It says just the 3 you've done, but don't just do the assessment. Don't just send the document that you get from the tax department saying that you're getting this much refund or you owe this much money. You need to send your whole tax return
so
and
they
make
can
sure
see what they're assessing.
Yes, and make sure they do too.
Okay.
Because sometimes you'll see things like interest from foreign investments and things that will raise some questions for you. Yeah.
So that looking at the tax return assessment is very giving.
Tax return,
Yes, yeah.
is a lot more informative
than just the
assessment.
number.
And they've signed it, they've sworn it's true, so you can really
Okay.
hone in
There
on
you
that.
go. There's a mum tip for you. That's one off the
There's
rank.
the tip.
Okay. So the other one is the completed superannuation form for each of your superannuation interests. So that's the SIF form that we talked you through in our course.
The Form 6.
The Form 6. So you have to now complete that information.
And send it to the other side. And so does your ex. And what's good about that is it was always on the financial statement, but nobody ever did it.
So they're enforcing that now.
Yes. But it used to be hard because sometimes people don't know what super their ex-partner's got. And so that requires them to disclose their superannuation. And, of course, you can double-check it if you ever go to court.
Yeah, because it's in the portal.
Because it's in the portal now.
Yay.
Yep.
Okay, and then bank statements of any account for the last 12 months.
Yes.
Now, we've had some listeners write in, actually it was a lovely member, and someone, they unfortunately ended up in the court, nearly at court, and the ex's lawyer was asking for 3 years of bank statements.
Yes, well, I think you wave this central practice direction around in front of that lawyer and say, no, you're being excessive there. It's the last 12 months. And the central practice direction and the disclosure section says that's what the court would expect. Anything beyond that is likely to make it much more expensive than it needs to be. I mean, if you've got a very, very wealthy client and things have been really happening and for instance, that several $100,000 went in last year,
then you
might
would want
ask
that
for a
one.
bit extra.
Yeah.
But yes, so we're trying to just keep it relevant to the time. And so it just, so you use that.
That's where it can get expensive though. Like if you've got 12 months worth of bank statements and you've got a lawyer, do you go through 12 months worth of bank statements as a lawyer?
Yes.
And how much does that cost?
It depends how long it takes and how much activity there's been on the bank statements.
Gosh.
But, people have several bank accounts.
I know.
The thing is with the lawyers is that if we don't, we could be sued if we haven't picked something up.
You have to go through.
We have to have a look at it. But here's the thing. Don't send them through one at a time to your lawyer. If you've got a lawyer, don't send them through one at a time. And I'll give you some other tips later.
Yeah, at the end, how to present it.
How to keep it so that it's not... they ask, you give, they hand over, all of that. Just keep it. So they have to read it. But if you send it in a block, they'll charge in a block of time for reading it. And I know what I'm looking for. Most lawyers do. They're not looking... to whether someone spent money on roses.
So other listeners have written and said, I don't want to give my bank statements because I went and bought lingerie from an adult shop, or, I did this, or I've bought this and I'm embarrassed that they'll find out. So do lawyers just ignore that?
We do, because we see it all the time.
Right.
We know everybody's secret.
What about if on the bank statements they're constantly going to the bottle shop?
Well, that's relevant. Or if they're drawing out lump sums of, I've seen them where there's $500 twice a day from an RSL or a club or something. That's relevant.
Okay.
And then you might look back a little further. But the other stuff, look, I promise you, if you redact it, like if you draw a big black Nico pen through it so you can't read it, what is the other side going to think? That's where she's taken money. So leave it there. It's nothing the lawyers haven't seen before, and it's you. You're just being authentically you, and let them worry about it.
I've heard some funny stories with disclosure. So, okay, I get it. Bank statements the last 12 months. Okay. Share investment statements.
Yeah.
So stock
if you've
market,
got any of that.
Bitcoin. Pay slips for the last 3 months. Why do they only want 3 months of pay slips but a year of bank statements?
Well, because your tax returns show your income for the year.
Yeah.
And it just proves whether you've had a sudden increase or a sudden drop.
Okay.
And so, you just do that.
Okay. Details of any government payments, Centrelink.
Yeah, all of that you get.
And a copy of any relevant medical reports.
Yep. So if you can't work because you're off work with your back or something's happened, or if I think anything that's relevant with, like if you can no longer, say you're a panel beater. I don't know how many of our ladies are panel beaters, but
they might be, Mum.
They might be.
Why do you always use panel beater as an example?
Because there are a lot of cases about panel beaters.
Really?
Yeah. There's cases. Well, in the old days, like 10, 20 years ago, a lot of blokes had a panel beating, and they used to do it under the house, like around the yard.
Okay.
And you couldn't sort of relocate that business. Where if you're a computer programmer, you just pack up your stuff and move.
Gotcha. All right. So
back to our panel beater. So say you're a cleaner normally, and you were really earning good money as a cleaner, but you've hurt your shoulder.
Yeah.
You'd put that in to say, look, my income's going to be lower. Here's my 3 months pay slips, or here's what I've been drawing because I've got an injury for my shoulder, and here it is.
Okay.
Or if you've got some other long-term disability or illness that's likely to affect the future needs.
Right.
Yeah. Then you can put that in. If you know you've got some sort of sleeper thing happening and your future could be a bit uncertain, or I've had them where you've had surgery and you know you'll have to have more surgery in the future. So you put all that in as well.
Okay. Now there's credit card statements, which are kind of the same as bank statements, I guess.
Yeah.
Lease documents.
Yeah.
Rental agreement, personal loans, any finance documents, car loan documents, contracts and statements.
I'm not so sure with rental agreements if I would send that if there is a problem with stalking.
Okay.
And
we were going to bring that up. But let's bring it up now.
Sorry.
Yeah,
yes,
but
because it's getting there, isn't it?
Yeah.
And if they know where you go to do things, if you've got your credit card statement and they know you always go Coles on Saturdays or something, so that's a bit of a risk.
If you are feeling like you're getting stalked and you are worried about because you might be listening to this and have not done disclosure yet, I know a trick that a lot of women that we've worked with in the past have done is taking cash out.
That's absolutely right.
And that way you can't pinpoint them
where they are.
That's right. Because you are using cash.
And you can buy your lingerie for cash.
Okay, so yeah, but when it comes to rental agreement, Mum, if you've got a domestic violence situation or you're worried about stalking,
I'd redact that.
Redact it.
So that, it might be relevant if you're trying to establish you've got a secure home for the children.
Yes.
And especially in these days.
Yes.
Then you might want to show that the rental agreement is this much and for this length of time and this is how much you pay, but you can redact the address. The court won't force you there.
Okay.
They do say in the Act that where it's going to put you at risk, you're not required to make the disclosure.
Okay. Now, in our disclosure checklist that you can download, there is a checklist also for companies, if you've got a company, but you can have a look at that. Also, if you've got a trust, there's a lot of information you need to provide with trust. Is there anything you want to say on those before
I do.
And businesses?
Yeah. So sometimes, particularly if the relationship's been a little bit one-sided, a little bit coercive control, the other person might be the person who knows all about companies and knows all about the trusts, and that is the disclosure they have to give. If you're the person in control of it, you give the disclosure. But so it cuts both ways. Okay. And it really is. I tell my clients it's a bit like turning your pockets inside out to prove you haven't got anything else, because what people think people have got can hold up a whole settlement.
Well, and literally this all this work, because then there's also physical asset disclosure. So that's the real estate agent appraisal of any properties, your red book valuation of your car, your boat if you've got one, your caravan, bikes. So
and your furniture.
It's basically putting a number and showing what the numbers are for everything in your world of finance.
Yes. This is what I say and here's the proof. This is what I say and here's the proof.
And really when it comes down to property settlement, Mum, particularly property settlement, it all comes down to everybody arguing over what the property pool is.
That's right. Or
then how much they get.
Yeah, so the first bit is always just establishing the property pool. And that's got to be done before you go to mediation, really. And unless it's done, you can't really have a sensible discussion about settling it either.
Because how can you say, and you've said this before, if you don't know how much you're fighting over, you will never get, you're never going to be able to decide who gets what.
Unless you just give up.
Yes.
And then you don't know what's fair.
Now, takes us on to the next one. Some people do want to give up because the other side is just clamped tight, refuses to give details. There's no information provided. And we do get oodles of messages about people saying, my ex won't disclose, they won't let me know. And we do our DIY disclosure episode.
Yes.
But what can you say to them so that they can stop stressing?
I can say to them that your ex will get their comeuppance when you go to court because the penalties for non-disclosure are set out in that practice management central practice
which
direction.
We'll put in the notes.
We'll put it there, yes. And so penalties the court will impose now are things like award costs against them, and if they're really recalcitrant, they may just make orders by default for whatever you want. So you can just change it to have 100% of the property that you know about.
Has that ever happened?
Yes. The court threatens,
Whoa.
because they've got no patience anymore with people who string things out. All I have to do is write to the other side and say, well, if you don't disclose, I'm asking for default orders for 100% of the property pool. So what are you going to do about that? Next thing they're handing you documents.
Very general advice. So this is Australian family law, and Mum doesn't know everybody's situation. But if someone right now listening in their car or while they're doing the cleaning and they've got an ex who won't disclose their business information or their bank statements or whatever, what can they write if they're self-repped?
Okay, you should just laugh quietly to yourself and rub your hands together and write to them and say, fair enough, I think it's worth about this, and give a high figure. And I'm going to ask for default orders, particularly if it's their application. And then because coercive controlling people often start these things and then balk at having to give the evidence. So you just point out to the registrar or whoever you're before next time that they haven't made proper disclosure and have your evidence. Here's the days I wrote and asked. They haven't done this, so I'd like orders by default. Now, a registrar may or may not, or a judge may or may not give orders by default on that day, but what they have done for me in the past is they note at the bottom that the respondent has asked that on the next occasion, if disclosure hasn't occurred, that default orders be made in terms of their response.
So basically, they can't smack on the bottom.
Well, they can't get the stuff to you quick enough.
Okay. All right. So that's court. But what about disclosure for mediation?
Same thing, I think. You threaten
with a mediator?
Well, they'll hold up the mediation. So you would have to bring it to court.
So there's that thing. Here's one of these things people have been in. They've been invited to mediation through the pre-action procedures. They have to go, but they're saying, but I don't want to go. It's going to be a waste of time. The other side hasn't disclosed.
Well, I don't think...
But they don't want them to get that certificate.
Okay, so you've got to be careful. Okay, so you're talking about the certificate for the children's matters.
Yes.
If you'll have to make an assessment of your own case, but if there is something not disclosed, if you don't think the mediation will be successful, you've got to choose whether you have to go anyway just to stop being told that it wasn't fair, or whether you say, I'm not wasting my money until you disclose this. So children's matters would be slightly different, I think. There's always benefit talking about kids. But when it's property, you can say because there's in the central practice direction, my new favourite thing, there is a list of documents that should be provided to the mediator and a date by which it should be provided. So if they don't provide it, they've cost you or they've failed the mediation.
Yes.
And then if you have to go to court and the court says, have you taken genuine steps? You can say, well, I have, but they haven't. They didn't disclose. And then there could be cost consequences again. Okay. I know it's frustrating. You've got to... The bottom line is you can pressure them to give you stuff, but the only way you can actually get it if they absolutely turn into a statute and won't is through subpoenas and...
Okay, so that's the next stage.
Yeah.
And I guess, but like you said, you can say to the judge, well, disclosure hasn't occurred, and then the judge can do their judgy things.
And you can write a letter to him or his lawyer and just say, I'm dobbing. I'm going to tell the registrar I'm going to file an application and I'm going to put in there that because you didn't give me, and be precise, 1, 2, 3, 4, these documents, you've got to know they exist.
Yeah.
Then I'm going to be asking for costs against you for these proceedings.
And this is all general advice.
Yeah, it's general advice.
But you can talk to, if you've got a lawyer, talk to them about it, but point it out and go, well, look, when it does come to property, if people aren't disclosing properly, it's kind of like just arguing for the sake of arguing with no real end point. That's what I see it as.
That's right. It's them trying to get you to accept their point of view without giving you the evidence by which you should.
Which is not fair.
Not fair at all.
So then it comes to, so that's if they don't. And of course you can also use your DIY disclosure and find out some of the stuff yourself.
Oh, a lot of the stuff yourself.
But what happens if you think it's too much? What if they're demanding and they're refusing to go to mediation, or they're demanding that unless they have the last 10 years of your bank statements and the last, every possible thing that is not listed in the central practice directions for a disclosure, what do you do? You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum and family law accredited specialist, to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today. What happens if you think it's too much? What if they're demanding and they're refusing to go to mediation, or they're demanding that unless they have the last 10 years of your bank statements and the last, every possible thing that is not listed in the central practice directions for a disclosure, what do you do?
Well, you go back to your central practice direction and there is an obligation on lawyers and parties, so not even if they're self-represented, to keep the case at a reasonable size and not spend too much money, or a disproportionate amount of money on the thing. So if they're asking for stuff that's not in the central practice direction and there isn't any real good reason for it, call them out on it, because it may be that they're either trying to run up your costs or they don't know maybe, or something, or I hate to think the lawyers might be doing it, but that's not necessary, and refer them back to the practice direction and say, unless you can give me a good reason for these other documents, I'm not giving them to you.
Now, and we're going to talk about how to give them to the other side, but if you are with a lawyer and they've got a lawyer and you provide disclosure, does your ex get to look at it all?
Yes.
Okay, so your ex still gets to see it all?
Yes.
Okay. So some people are worried about stalking, like we've already mentioned. Is there any way, like with subpoenas and with disclosure, to protect yourself?
Yeah. Okay, so with disclosure, the Act says that no matter what these directions say, it's always got to be safe. So you can put to them that you would disclose it, but it's not safe, or you're disclosing it, it's redacted in certain things. You might leave the amount, say in the tax, in your credit card, but cross out where it was you shopped, something like that. Yeah. I think that you can protect yourself that way. And sometimes some of the stuff they want is just nonsense and it's going to run up the cost. So just keep that point to them that it's got to be within the range of stuff that's going to help you prove your case.
Okay, all right. So when it comes to actually doing it, now in the old days, even as back as the old days as when I was going through it.
And when your grandma was a baby.
Scanning it and uploading it and emailing it.
Yeah. Page by page
or zip filing it.
Yeah.
So what do people do now?
Well, and before that, we used to go over to each other's offices and spend half a day in their very uncomfortable chair in their interview room going through the stuff and asking for copies and putting sticky notes. So now then it went to you. Soft copies were great. And now the court has said, look, you've got to do an index and you will normally need a Dropbox or a Google Drive or something. So most people do that. And then you add your documents to it, add to the index and upload your document. It's all there. They're all clickable links and that helps everybody really.
And a good tip, like you've said, Mum, is because the disclosure has to continue the whole way through till finally settled. Yeah. So if you do get a new bank statement, do you just upload it?
Well,
because that sucks.
Yeah, not if you're going to a lawyer and giving them one bank statement at a time.
Okay,
There's a fine way of running up your bill too much.
Yes.
Yes. So every few months,
just here you go, here's a new data dump.
Yes.
Wow.
I know. But
so
hopefully the court's new system, they're very much hoping that all the cases will be finished in a year.
So when they're uploading and giving all the data across, so one of our listeners, imagine they're listening today and their ex is disclosing. So what does the lawyer do? Do they write to them and say, hey, I'm about to give your ex is giving us your disclosure. Do you want to look at it? Like, is that what?
No.
What do they ask from your clients when it comes to disclosure?
Yeah. So we say, for your information, here's the disclosure. Have a look at it. Let me know if there's anything you're worried about. We've had a look at it. We've just noted these 2 things or these 3 things, and can you shed any light on that?
What's the weirdest thing you've ever seen in a disclosure document that made you laugh?
It did make me laugh. It was a bit of an aha moment.
Yeah.
A person who said he was away at a certain Queensland town working was actually in Hong Kong.
Oh, a mama.
Yes.
Busted.
And buying jewellery.
Or did someone steal his credit card?
No, he was there.
Oh, that's busted.
Yeah,
So not only does disclosure show what you're spending your money on, it shows you where you are, what you're doing. So if that was redacted, well, you would have said, why is it redacted?
Why is it redacted? I'd have put on a real turn because we thought he was dodgy. Yeah. So there's a lot to be said for just being open and transparent. And there was nothing wrong with him going there.
Well,
so I don't know what his problem was.
Oh, there you go. That's just one of those people that just love lying. Maybe.
No, I think he was trying to build himself up as something he wasn't. But, so just tell the truth. It's just easier.
Yes.
And, most of the things that you're worried about, lingerie, etc., doesn't even cause a blip in the radar of the judge, and it can't be used in court. It's just something we just gloss over and go, yeah, right.
So when it comes to us saying maybe if you don't want people to know, get cash out, what if you find a bank statement and it's all just cash withdrawals? Is that a red flag?
No, I have a look and see how much it was. If it's like that person with the $500 withdrawals a day from the club, I don't think he was spending that on groceries. Okay. So there's a reasonable living expense, you know. And if you can see that, for instance, that the mortgage payments are up to date, it could be that it's cash. So, yeah.
All right.
People so some people, sorry, Laura, but some people, you might have heard me bang on about my budgeting system.
My partner does that now. He just uses cash. I hate it.
Yes. So I do too, that Ramsey thing.
Yeah.
So there's a lot of people who do that when things are tight.
Yes, which is a great idea, except like some of the banks are refusing to give out that much cash these days. Just there was like a sign up the other day saying we only give out a certain amount of cash every day or something per person.
Oh my goodness.
Anyway, so when it comes to the different personality types and disclosure, also before we do that, if you do end up in mediation or at court and you've been given something that has been disclosed that's like you said, that guy was in Hong Kong when he said he was working, how do you use it? How do you say, look, dodgy or look cheating or hiding or money's
I
stashing.
think in that case, it didn't matter a hill of beans. It just didn't matter.
Oh, okay. But what if you find something that matters? How do you point that out to someone?
Your barrister will know about it.
But if you're self-repped,
self-repped, you would write a letter and do them an AHA and tell them you're dobbing on this and invite them.
Other side,
side.
I found out.
I've seen this document. What is the explanation for this?
Oh, God.
Really? But you wouldn't...
Gotcha.
Yeah, but not on lingerie or going to Hong Kong.
No.
But like if someone's invested, one guy, $13,000 just disappeared and then he started getting money from this ATM thing. And it turns out he'd bought ATMs. I didn't know you could do that.
Yeah, you can.
Yeah. And so he'd quietly peeled off money and bought ATMs, which we picked up.
Right.
And that was interesting because rather than tell us all about it, he settles.
Well, there you go. So disclosure can be a way of getting someone to go, oh, I've been busted. Yes, I'll settle.
Yes, because if they've told lies, big lies, like the only reason you'd use that Hong Kongy type thing would be to prove that they don't always tell the truth, to establish their credit.
If they're telling other lies, you want to be able to say, well, here's an example of a lie,
that
we've proven is true.
Yeah, that he swore it in an affidavit, and here's the evidence. But, you always should be thinking about how you can use it to settle.
Okay. So do people settle without disclosure?
Some people do. You can't do it if you're going to get consent orders in the court because the court has to know that the orders are just and equitable.
Okay.
So the only time it comes up is if people are just doing it between themselves, which isn't a property settlement anyway.
Yeah.
Or if there's if they're doing a financial agreement. If they do what we used to call a binding financial agreement, you don't have to make disclosure in that document. But holy smokes. It's some
risky.
People, it's risky. Look, some people will say to me, he hasn't got anything. I know he hasn't got anything. He just wastes it. And so I don't need to know, and he's probably not telling me because he hasn't got anything and he's embarrassed. So, they can do that. You can do that. I think some people do just give up and go, look, it's chicken feed anyway. If you get them to swear a financial statement that this is all they've got, you're entitled to rely on that. So even if you're just doing consent orders, get them to fill out that document. The application for a consent order has all their information and they've got to swear that's true. Then you settle. You haven't seen the proof of the documents, but he's sworn that that's the document. That's what they've got. And then if it later turns out they're sailing around the South Pacific in a yacht they had, you can reopen it and say to the court, he lied.
He lied in his
he swore this. I only
agreed
agreed because this is what I thought the property pool was. Please reopen it under Section 79A or the equivalent. Yeah,
but it's better to know.
Yeah, I think you just want it over. It's better to know, but some people just don't want to die in a ditch over that last couple of dollars, And sometimes you have to ask yourself what difference it will make. Yeah,
if it makes a huge difference, then you should.
Yeah, so if you're going to get 50-50 of a $100,000 property pool, well, that's $50,000. If it's hidden 5,000 of it, that might not be worth the cost of going to court.
The legal fees of going to get people to look at it.
That's right. And the anxiety and the stress and the delay and the uncertainty. So there's,
Do mediators or judges look at the disclosure or only the bits of information that you provide to them?
Yeah, only the stuff we provide to them. Okay. We would go through and go, this is really relevant, or oh no, we've checked that, that's all they're earning. This is, this all seems okay. Or hang on, what's this extra money coming in? Or what's this promotion? Or how come that person's putting an extra $300 a week in their super that they didn't normally have to put in? So they actually have money to spare. If you're looking at a spousal maintenance claim or something, or they're not paying the mortgage, but they're feathering their own nest by putting money in the super. So, the court can't go through all that. They'd go crazy, the judges. So what they do is they rely on the solicitors to verify, check what needs to be done. Anything that's really relevant would then be given to the mediator or to a judge. If a mediator forms a view that a person hasn't been fair dinkum in trying to resolve the case, then sometimes they'll say that in the 60I for children, they'll say that, didn't give a fair go. With property matters, I think you can only make the allegation.
Right.
Yeah.
Okay. So when it comes to the different personality types and disclosure, avoidant disclosure must be very hard.
It is. If they're just genuinely avoidant, because either they don't want the marriage to be over, or they just can't be bothered, or they're depressed, then you've got to make it easy for them,
And if you're avoidant, and I remember having to do the disclosure, and I was like, put it on the bottom of the list. I left it for so long because it was just a horrible, monotonous task.
It's massive.
You have to sit there and download your bank statements. You get all that information. It's just, you're like, okay, that's going to take me at least half a day.
But I think the new directions that limited zone, that was good, because you just have to do those, and then they've got to establish why anything more than that is necessary, and you've covered yourself if you do that.
And the eat the frog first situation, and I know we've said this in other episodes, but if you are an avoidant, and not because you're a bad person, just because you just can't,
overwhelmed,
like that lady wrote on Facebook the other day, I can't do anything you're saying because I just can't deal with the emotional trauma that I'm going through, and we get that. But if you ever have a good day where it's spare, I mean, no one ever has a spare good day these days at the moment, but if you do find you've got a spare good day, maybe your mum's looking after the kids, maybe you've got a public holiday or something, try and get the disclosure prepared now, before you need to do it in a hurry.
That's right. You know what's going to be needed.
Yeah.
That's exactly right. And don't be tied up with perfection. Have a go at it.
Yeah, and if they see there's something missing, they'll let you know.
Sort that out. Yes, that's
if it's self-repped.
Yeah.
So you'd send that drive link to the other side, or to the other side's lawyer.
Well, yes, if you're not haven't got a lawyer. So this is what I say. People can save a lot of money if they have, and I get that people can't. Sometimes they just can't be doing. But the reality is, when your lawyer asks you for it, it's no easier. So it's better in a way to be proactive and be able to say to your lawyer, look, I've got, here it is.
I've done his disclosure. I've done my disclosure.
Yes, here's the index. Here it is. Just quickly scan it through. And if you've got a lawyer, you can't really talk to the other lawyer.
Yes.
But if you haven't got a lawyer, you can do it directly.
Okay.
And just get it done. It's a waste of time, many, many letters back and forth. You still haven't done this. And people did used to. You'd give them everything, honestly, everything. You were cleaning the lint out of your belly button to send to them. So they had everything.
And
then you'd come up to a trial or a mention date and they go, 4 o'clock the afternoon before, you haven't given us this, and you think, and then they go before the judge and go, she didn't give us this. Whereas now they actually say that they're satisfied with the disclosure, and you give an undertaking that there's nothing more to give.
Right.
And it just kind of keeps it contained, because it did used to be, and because you'd be like 6 months between mentions in the court, and some people, the lawyers would wait until a week before and go, we want updated disclosure. So, just keep it going. I think eating the frog first and setting aside time is one way of doing it. When I'm overwhelmed, though, I'm better to use, like James Clear, that Atomic Habits, just to do a little bit every day.
Yeah.
And then it doesn't feel so bad.
So you could download our checklist and go, I'm going to do one thing off the disclosure checklist every day.
Just before I have my glass of wine, or before I have my coffee,
before
I eat that chocolate. And then reward yourself at the end. So it just depends on your personality and where you're at in this journey.
And I know sometimes, because we're talking to each other, we forget that these people, some of our listeners are going through hell. Like you might be literally going through hell. You're moving house, you're packing up house, you're couch surfing maybe.
You don't know where you're going to be living.
You're in between 2 different new worlds. Like your next life's going to be amazing, but you've got to get to that point. And this is the yucky bit you got to get through.
And the lawyers do tend to, we do, and we don't mean to, but we do tend to be a bit businesslike about it and treat you almost as though everything's hunky-dory.
Yeah, everything's fine. You're totally fine. Your life's fine.
But actually, no, you're like,
your life's
while you're doing
apart.
that, and the kids are probably playing up and all of that. So we get it. I don't want to sound too glib.
No.
But
give it your best shot. We know that you're going through hell, but unfortunately there's no excuse to the
court, yeah.
to say, I'm sorry, but I'm really struggling.
You know, the court knows that getting it done is the best way to get you through, and then you'll be on your way to emotional and financial freedom. Yeah.
Yay.
So you've got to get through in one piece.
Okay, all right. Manipulative and controlling. Disclosure and manipulative and controlling.
Yeah. So they're likely to have a little plan maybe to run up your legal costs by asking for weird things again. Use your central practice direction as a shield. They may be wanting to dig for more things than they're allowed to. Yeah.
So that's when you say, what if the lawyer that represents you, say some of them are represented by a lawyer, and they say, oh, the other side's asked for bank statements for the next 7 years. Do you say to your lawyer, I'm sorry?
No, tell them no.
Okay.
Say to your lawyer.
So you can say no to your lawyer?
Yes.
Okay.
You can say, but doesn't the central practice direction...
So you can
don't dob us in.
Click the central practice direction,
and
download it, and go, I thought number
I thought it could only have 12 months.
Yeah.
Have they given a reason?
So asking for a reason before doing silly.
Yeah, if it's not specified, ask for the reason.
Okay.
Why?
So manipulative controlling, probably look for the sneaky tricks that we've talked about in the DIY disclosure. Yeah. So that's so credit cards that are on the positive instead of a negative. Some people can miss that.
Yeah. Also, if they've got a betting account, that can have positives. That's a bit tricky. Also, they may get into you and ask for details about things they know will hurt you, but it might just be a red herring and they're hiding something. Sometimes manipulative and controlling people don't realise that they project onto you. So
it's a
when
good
someone
sign.
goes,
if they're asking for it, you should ask for it.
You must be hiding money. And you go, oh, why? Are you hiding money?
Brilliant. Okay. All right, that leaves high conflict mum and disclosure.
Yes. Same thing, just work to rule. Keep them there. Keep them contained. And
point out their bad behaviour to the lawyer and go, no, this is in the practice directions. We're not supposed to be doing this much.
That's right.
Yeah. And if they want to ask more details of disclosure, so you've provided it and they want more information, you've got it.
Reasonableness, I think.
Reasonableness.
Because if you don't, think about this. What if they go to court and ask a judge, will you look like you're being sneaky or will you look like you're being harassed and you're just not getting into it? So, and if it's easy, do the blooming thing.
And we've always said with high conflict, the best way to shut them down is to provide irrefutable proof.
Irrefutable proof. Absolutely.
Proof. And then they can't argue.
Down.
They can't argue. So even though you might have to do a little bit more painful work for them, I guess that's what it feels like.
Yeah.
You're shutting the argument down.
That's right. I mean, and if it's a simple thing, don't make a big issue, just send it, you know. Sometimes they get a kick out of knowing that you don't want to give it, do you know? So, so just be careful with that sort of...
Talk to your psychologist.
Yes.
And go, how am I supposed to deal with the fact that my ex knows all my personal comings and goings for the last 12 months.
So you need to know that if you ever end up in court or in a mediation, and let's face it, we all have to act as though we might end up in court. Every letter we write, every document we don't produce. Every text, everything is probably, imagine it's going to be read out loud in court by some barrister.
Oh, God.
So we're all... likely, like even if you're not going to end up in court, you need to act as though you are. So you have to conduct yourself really well, and put a lid on it. Like you said, counsellors.
I find it funny, though, this is digressing because we need to talk about amicable, but barristers or QCs or KCs or judges even reading out things that are inappropriate, like inappropriate texts, and if they do it in a proper English accent.
I know.
Like I've seen that on the TV. Have you seen that in the court?
Yes. So the court, things have changed. Time for another little quick story. Okay. So years ago with divorce, where there had to be proven a infidelity or desertion or cruelty. Sometimes you would write down on a little piece of paper and give it to the judge in an envelope what what the person did, like infidelity, and it was called a discretion statement, and the judge would just have a look, raise his eyebrows because they were all men, put it back in the envelope, and then that was never
fire and throw it away.
And then also, and even when I started in practice, if someone said a swear word to your client and you wanted to give evidence of it, you would write it on a page, show it to the client. Is that what your husband called you? Yes. Show it to the judge.
Oh, wow. But you can swear now?
Well, I wouldn't.
But you can.
I never do. But that people don't seem to redact, they don't seem to take that out anymore.
Oh, wow.
Because you used to do things like F, star, hash, $, whatever.
Oh, gosh.
But now people seem to be a little bit letting it all out. But I'd be very careful not to offend the court.
Yes.
You've got to, it's a dignified thing.
You've explained it, and I think disclosure is kind of like, I see the court as like the principal's office.
Yes.
And I see disclosure as like your homework. And like you've always said in lots of other episodes, you've got to have clean shoes, a clean face, your hair done well, and you look like and act like the best kid in the class.
Yes.
The teacher's pet.
Yes.
Yes, I've done my homework, Your Honour.
Yep.
Yes, I'm here on time, Your Honour.
Yes.
Yes, I speak to you with respect.
Yes.
Because if you don't, that's giving, even though it shouldn't, but it's giving them a reason to not like you.
That's right. It's like a job interview because they haven't seen you before.
Yeah.
And by the time you get before a judge, they've probably read what your other ex has said about you, which is probably not complimentary. And then they've read what you said about the other. They don't know who to believe. It's just some person you don't know. You two pop up and they go, oh, I don't know. But make a good first impression.
Yeah.
And don't be that person who has been stuffing around with disclosure unless it's begetting unreasonable. If they ask for something and it's not in that little guideline, but it's not that big a deal, don't make it a big deal.
Yeah.
Just send it over.
And with amicable, I guess you just follow the rules.
Yeah.
Look at the checklist, do it all anyway.
Yeah, sometimes people do it together.
But do it.
Yes, do
Just
it.
because you're amicable, because we've done an episode which I would love you to listen to called Amicable, When Amicable Goes Wrong.
Oh, yes.
But you should do the disclosure even if you're amicable.
Yep.
Because you might find if they don't want to do it, then it's not amicable.
That's right.
But it's also the better you know.
It is. And when they go, let's not get lawyers involved.
Let's not do disclosure.
Let's not do disclosure.
You don't need to see what my bank balance
We can just
is.
agree that this is the property. You tell your lawyer, yes, well.
That is a red flag.
Yeah, you need to look and you need to show. So everyone needs to turn their purses out, turn their pockets out and then everything's clear. Because at the end of the day, the court has to make an order that is just and equitable.
Yeah.
And if they don't know the facts, they won't. And you at some stage have to swear a document
that says
these are my assets, and the other person has to swear these are my assets.
Okay, so you make sure they're like, let's do this amicably, let's just get it through. Make sure they actually are going to be amicable. It's not just words, it's actions. And one of the actions is showing their disclosure.
Do you know, if you were buying a house off someone and you made friends with them, you still do all the searches.
Yeah, that's true.
You're still, you're still careful.
Sure. Yeah.
It's a sensible business deal.
Yeah. Okay, because you might end up with debt. If you would like to listen to our divorce, debt and STDs, sexually transmitted debt, you could also end up with debt if you don't do your disclosure
Absolutely.
properly. So
because
it's important.
Your lawyer will, or you, if we've told you how to do your discovery, where you do searches, make sure there's not any other properties around, make sure there's not any
loans.
businesses, any loans, any liabilities that you've got. Rack your brains. Have you been a guarantor on a document? I've had people who have signed documents when they've just got out of one lady many years ago, had pneumonia, and on the way back from the hospital, she was very ill. He dropped in at a car yard and she signed a guarantee on his four-wheel drive.
God. Yes.
And almost forgot she'd done it. Same with if you've just had children, or if you just typically you trust that person. If they put a document in front of you, usually just sign it. Oh, yes.
Yeah.
So you need to check. You might not check much during the relationship, but when it all goes to putty,
you've got to.
Yeah.
So if you are interested in downloading our free disclosure checklist, go to the divorce course, www.thedivorcecourse.com.au, and you can download that checklist. I'll also put the link in the show notes. And if you have not considered giving us a review yet, we would love it if you could. Yes. Even if you just don't want to write anything, just tap and give us 5 stars. That would be great.
5 stars is great.
5 stars would be great.
Perjure yourself.
But if you would like to leave us a review, every month we choose one lucky person to get a free chat with Mum, and last month's person is very excited. So she's already booked to talk to you, Mum. So we would love for some more reviews, because every time we get a review, it pushes our podcast out to other people who are just like you, who might need it. So thank you, Mum, for your information on disclosure, and
lovely
good luck to
you,
all of you out there who are going through the disclosure dance and going through divorce or separation. Our hearts go out to you again, and we love hearing from you. Please keep messaging in and giving us kind of the direction on which we take all our episodes.
Absolutely. And you know, you're all on the path to getting out.
You are.
Whatever stage you're at, you're on the path now.
If you're listening to us, then you're on the path.
You're on the path, and it will end.
You're sorted.
Yes. You've got Team Us.
You've got Team Us. All right. Thank you, Mum, for your time. Thanks, everybody. Take care.
Bye.
Bye. If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.